appeals in the matter of Gutmann, London and South East Railway Limited, first MTR Southwestern Trains Limited, and another Yes, Mr. John.
May it please the Court, the claim as originally formulated in these proceedings appeared to allege that the Chapter 2 prohibition of the Competition Act obliged the defendants to ensure absolutely that all customers were sold cheaper available boundary fares in circumstances where the customers were eligible to receive them. And as I will show you, it appeared also that the class definition was formulated on that basis, and so too, importantly, was the methodology advanced to quantify loss. In its reply, however, the claimants changed course, or as they would have it, clarified their position, asserting that it was not taking so absolutist a position. Instead, the allegation of abuse became, in summary, that boundary fares should have been somewhat more widely available to consumers than they in fact already were, and that they should have been better promoted by the defendants. The claim for damages, therefore, could only be based on the proposition that with the greater availability and greater extent of promotion, there would have been an increased uptake of such fares by those eligible to receive them. Now, save for Mr. Harris's point regarding supposed abuse in relation to discounted fares, neither of the appellants on this occasion seek to debate whether the claimant's reformulation of their case on abuse amounts to a coherent or sustainable proposition of abuse of a dominant position as a matter of law. That will have to be debated in due course, either at trial or by way of preliminary issue. But what we do say is that a claimant seeking to bring a collective claim for aggregate damages must put forward a plausible methodology by which those aggregate damages are proposed to be calculated in such a way that they will reflect the loss to the class occasioned by the infringement as alleged. And the fundamental difficulty with the claim put forward in this case, and the principal basis on which we bring this appeal, is that the issue of causation or reliance by members of the class is an essential component in calculating loss under the claim as now formulated, and yet there is no plausible methodology whatsoever proposed by the claimant as to how it intends to measure that critical issue, whether individually or collectively. Put simply, the class representative puts forward no methodology at all as to how he plans to measure the amount or the extent of increased uptake in boundary fares that it is alleged that the better availability and promotion would have given rise to. Instead, the claim seeks to proceed on the basis of an assertion or an assumption that literally everyone who could have bought a boundary fare, or at least a cheaper boundary fare, would have done so. Now, that is an assumption that quite understandably has an initial attraction. But we respectfully say that once one reflects more carefully on the nature of the abuse and the variable circumstances of the underlying claimants, it is not an assumption that is warranted. And it is certainly not an assumption that can substitute for a workable methodology as to how to calculate a central issue in any aggregate damages calculation. If uncorrected, that approach will inevitably lead to systematic overcompensation to the class, potentially on a very large scale. In short, a plausible methodology to calculate causation and reliance is required in law, but it is absent. And that, in summary, is the key point that we make. Now, in order to develop that point, my submissions will, with the permission of the court, be divided into 5 parts. First, I will slightly test the court's patience by advancing 4 propositions of law that I believe will be wholly uncontroversial. But I think they are important just to lay down as a framework. Next, I wish to delve a little deeper into the background to the claim and the true nature of the claim as now advanced. Thirdly, I will then come to the nub of it, when I will develop and explain why we say there is a complete absence of methodology to measure causation and reliance, and why we say that the assumptions that are made are not an adequate substitute for that plausible methodology. And after that, I intend to go back to the tribunal's judgment and to summarize where we say it went wrong.
Yeah.
And finally, if time permits, I will deal briefly with our subsidiary second and third grounds of appeal and how they support the main ground. So that's the roadmap, my lord. And if I could start then with the 4 propositions of law. They will be familiar. Mr. Harris has already touched on most of them. The first proposition is that in any claim for abuse of a dominant position, as for any tort of breach of statutory duty, the burden of proof lies on the claimant, not just to establish that the defendant is dominant and has committed an abuse of that dominance. The claimant must also establish that the abuse alleged caused loss or damage to the claimant. Loss is an essential component in the cause of action. The second proposition is that in considering what would have occurred absent the abuse, one must compare the actual world in which the abuse was committed with the counterfactual world in which the abuse was not committed. One doesn't compare the position to some counterfactual in which not only was the abuse not committed, but the claimant also acted in some other additional manner unconnected to the abuse. Now, I'm sure I don't need to go to authorities to make those first points, but for your lordship's note, it's the Britnett case supports both of those in this court, in the Court of Appeal, supports both of those propositions at paragraphs 28 and 29. It's in the authorities volume 6.1, tab 56B, at page 1.1997.192. Now, in the present case, what those 2 propositions mean, of course, is that it won't be enough to show that the defendants were dominant and abused that dominance by their sales arrangement for boundary fares. The claimants also have to show, and the burden is on them, that had the defendants sold boundary fares in a non-abusive fashion, that would have caused passengers to act differently by buying boundary fares. And the tribunal has, to be fair to it, rightly recognized that that issue of causation or reliance, as they put it, was indeed an issue in the present case. And it did so when it came to identify the relevant common issues between the class members. If I could ask you to look at that, please. It's in the judgment in the core bundle, at paragraph 135, at page 186. And you see in paragraph 135, the tribunal identifies that what it says are at least the following common issues that arise in the claims of the proposed class members against each respondent. And you see number 4, whether a customer who was aware of a boundary fare and had the opportunity to purchase it would have done so. So causational reliance is there rightly identified by the tribunal as an issue, and it finds it to be a common issue. Now, we accept that it's a common issue in the limited sense that in all of the underlying individual claims that comprise this proposed collective action, a necessary step would be to prove that absent the abuse, the claimant would, on the balance of probabilities, have purchased a boundary fare or boundary fares. But the first question is, can that issue be resolved on a common basis at all? Now, on the face of it, the resolution of this causation and reliance issue is a uniquely individual issue. It will depend upon the circumstances and predilections of the individual customer and the circumstances of the particular journey. For example, when the claimant in question went on holiday by train to Dorset, did they usually take their travel card with them? When they travelled on business, were they concerned to minimise expenses to their company? Did they arrive habitually late at the train station with no time to consider the optimal fare? Were the claimant rich or poor? Were they spendthrift or careful to save expenses? Were they travelling on a group ticket with friends that was actually cheaper than a boundary fare? Did they know when they were returning, whether they would do so on a day when their travel card was still valid? These are all the sorts of individual issues that will determine whether any one particular claimant would or wouldn't have bought a boundary fare in the claimant's counterfactual world. But the claimant has come to the tribunal and says, well, we can try these individual issues on an aggregate basis. And since this is a proposed opt-out collective action, they propose to do so without any evidence from any individual class members at all, because they don't have any direct access to the class members. It's not an opt-in. And that leads to our third proposition of law, which is that if a claimant wishes a matter to be resolved as a common issue like this and seeks aggregate damages on that basis, the claimant must propose and must provide a plausible methodology, one that is not purely theoretical but rooted in the facts, by which it intends to establish loss on a class-wide basis. Now, Mr. Harris has already shown you the relevant passages of Procis and Microsoft, paragraph 118, which has been endorsed by the Court of Appeal and the Supreme Court in Merrick's, paragraphs 40 of both judgments. And the tribunal indeed itself recognized that the Procis test applied. If one goes back in the judgment to paragraph 107, which is on page, starting on page 173. You see that the tribunal says, as regards the common issues, the Canadian Supreme Court has set out the following principles which we think can appropriately be applied under the UK regime. And you'll see over the page, subparagraph 4, the standard to be applied in assessing expert evidence designed to show a common issue is that it must be sufficiently credible or plausible to establish some basis in fact for the commonality requirement, and that it is not purely theoretical but grounded in the facts of the particular case in question with some evidence of the availability of the data to which the methodology is to be applied. So they accept in theory that test applies, and one sees that if one goes forward in their judgment, page 187 of the bundle, paragraph 138, they put the point in this way. They say, in our judgment, if there is a realistic and plausible method of estimating aggregate damages that overcomes the individual aspects of causation and the claims are suitable to be brought by way of collective proceedings. The claims are suitable to be brought by way of collective proceedings. So, they note the point, but the individualist issues can only be overcome if there genuinely was such a method before the tribunal. It was not proposed.
Do you accept the word estimating? That the process which is being applied is one leading to an estimation?
I accept estimation, but I also it must be a reasonable process of reasonable estimation. Mm-hmm. And what we do say is that the methodology must be one that matches the infringement that is alleged. Parties expecting to be certified should not be permitted to come to the tribunal with a methodology to measure some other or previously alleged infringement. It must be a methodology that is apt to measure the infringement that is alleged and pursued. And we also say that the methodology must be a complete methodology to measure all the common issues relevant to the assessment of the damages that might flow from the abuse alleged. We do say that an applicant can't reasonably expect to be certified if one or more critical element in the quantification is missing from its methodology. Put bluntly, one can't have a methodology with a big hole in it in relation to a key issue for quantification and say, don't worry, I'll work something out to fill that hole in due course. It must be a complete, plausible methodology. Otherwise, it's not what methodology to calculate aggregate damages, properly so called. And that's consistent with the fourth and final proposition of law, which is that in certification, the tribunal is to operate an important screening or gatekeeper role, which you will see from Lord Briggs's judgment in Merrick's at paragraph 4 and as indeed this court recognised also in Patterell at paragraph 108. And that the gatekeeper role is substantive. It's not mere verbiage, it's not merely symbolic. And part of that, important part of that process is surely to give careful scrutiny to whether there is a plausible methodology advanced, which is complete and apt for the infringement as pursued. And that's important because for a number of reasons, not least because of the formidable nature that these aggregate claims pose to defendants, but also because, and this is also important not to lose sight of another reason why the gatekeeping role is important and the methodology is important, is because in assessing the suitability of the matter for collective proceedings, one of the things that the tribunal has to do is to estimate the likely costs and benefits of the proceedings. And those costs can't be estimated unless one understands, at least in outline, what the methodological and evidential steps are going to be required. If you don't know what the method is going to be to prove and quantify aggregate loss, you can't budget for what that quantification is going to cost. So those are my 4 introductory points of law. If I could then turn to the precise nature of the claim that is advanced here, and just look at that with look at it a little more closely. Now, the allegation of abuse in the present case was originally expressed in a manner that was, to put it generously, ambiguous. And one can see the original formulation in the supplemental bundle, if I could invite you to look at that. The first supplemental bundle at page 39. And you see in paragraph 42, under the heading abuse, you see they say this: the abuse which is continuing consists in the proposed defendants neglecting of their special responsibility as dominant undertakings through failing to take any or sufficient steps to prevent class members from being double charged for part of the service provided to them. Now, pausing there, in this high-level formulation, you see the abuse characterized as a seemingly absolute obligation to ensure that there is no so-called double charging for any part of the train service. So, in other words, on this approach, the obligation on the defendants was to ensure that anyone who would have financially benefited from a boundary fare actually and definitively bought one. And we called this below, for shorthand, the strict liability approach. Now, it's fair that if they then go on in a less definitive form, they say this: in practice, the abuse consists in failing to make boundary fares sufficiently available for sale, and or failing to ensure, for example, through better staff training, amended sales procedures, or increased customer-facing information, that customers are aware of the existence of boundary fares and buy an appropriate fare, which avoids them being charged twice for their journey. Now, the first part of that formulation, failing to make boundary fares sufficiently available for sales, doesn't appear on its face to be an absolute obligation to ensure that an eligible customer that would benefit financially from it actually buys a boundary fare. It rather appears to be an allegation that boundary fares should have been made more widely available for sale from more outlets, as it were. But the second part of the formulation, after the words and or, you see it says and or by failing to ensure. And the word ensure rather suggests that they do, however, envisage such an absolute obligation.
No. Well, with respect, for example, failing to ensure, and then it specifies various things they should have done, that customers are aware of the existence of boundary fares.
Yeah,
So
but then
that's just saying, well, you should have had better publicity, as it were, than you did.
Well, my
it's
lord,
not an absolute obligation.
my lord, if I may, it says that are aware of the existence of boundary fares, but then it goes on. It says and buy an appropriate fare which avoids them being charged twice for part of their journey. So it is genuinely ambiguous and certainly suggestive in the latter part of the absolute obligation. The point for present purposes is that the notion of the claim as a strict liability one is then reflected in the methodology that was employed by Mr. Holt, the claimant's expert economist. And if one looks at the second supplemental bundle, at S 358, you go into Mr. Holt's first report.
Can we put this bundle away?
Yes, my lord. We will be going back to it, but forgive me, I'm going to be dotting around it.
So page 358.
Page 358, and you see the conditions under a heading, conditions leading to a claim. And we see 3.2.12. Says, as mentioned above, the claim relates to losses suffered when individual rail track passengers purchase rail fares for journeys between 2 points, spanning a zone boundary, where they would have saved money by purchasing a cheaper boundary fare. This leads to several conditions for a passenger to have a claim, which is a useful context for examining the factual evidence and damages quantification. Condition 1. The passenger purchased a rail fare for a journey that spans a zone boundary that is further from central London than the origin station. Condition 2, the passenger held a valid travel card, providing the right to travel for at least part of their journey. And condition 3, the passenger was not sold a boundary fare. So the assumption there, the built-in assumption, is that anyone who would have saved money by purchasing a cheaper boundary fare has a claim. And the same assumption is in fact also reflected in the class definition that was advanced. And you see that, if one, forgive me, if one goes back to volume 1 at page 48. At paragraph 88. And if you see there the class definition, all persons who at any point in the relevant period purchased or paid for a rail fare which was not a boundary fare, where, and then we have the two conditions, the person for whom the fare was purchased held a travel card and the rail fare was for travel in whole or part on the services of the defendant from a station.
Sorry, I'm a bit behind. I'm just catching up on the reference.
I'm so sorry, my lord.
Which bundle? Supplementary 1?
Supplementary 1, paragraph 88.
Paragraph 88.
Page 48.
Thank you.
And the court will see that it's clearly based on all people, all claimants who are said to have saved money by purchasing a cheaper boundary fare. It doesn't seek to identify only those that would, in the counterfactual, actually have bought such boundary fares. It just implicitly assumes that everybody in the counterfactual would have done so. Now, in the run-up to the hearing below, the CPO either clarified, or as they would put it, or as we would put it, beat a tactical retreat from its more absolutist formulation of the abuse. And one sees that very clearly in the reply, which you see later in this bundle, at page starting at the relevant part is at page 211. And you see in paragraphs 20 and 21, we see what they say. They say that there are different ways that the proposed defendants could have put an end to the abuse, doesn't render the abuse in any way amorphous. Equally, there are not two limbs to the abuse. A failure to make boundary fares sufficiently available and a failure to ensure that customers are aware of boundary fares and thus actually buy them are just two facets of the proposed defendant's failure to live up to their responsibility. insofar as the proposed defendants have seized upon the single word ensure to allege that in order to succeed, the proposed class representative is obliged to establish that the TOCs had a duty to provide 100% awareness and 100% guarantee that passengers always purchased a boundary fare, this is a purely semantic argument for the avoidance of doubt. That is plainly not their case. Rather, it is that the proposed defendants, in light of their special responsibility, were obliged to ensure in the ordinary sense, they say, of making sure to the best of their ability or exercising best endeavours. I'm not sure I would regard that as the ordinary meaning of ensure, but there we are. A general awareness of boundary fares so as to enable customers to buy an appropriate fare. Such awareness being a necessary part of the duty to make these fares sufficiently available in any meaningful sense. And they say that this topic is addressed further below at paragraphs 27 to 28. So the counterfactual is now, and we see also, if one goes forward to 28, probably should go forward, it's on page 216, they say 28A, at the bottom, the counterfactual is clearly articulated in the amended claim, see paragraphs 38 to 40. Now, we'll come back to that. But we see that it's then said, in this paragraph 28, that boundary fares would be available for purchase through, they say, through all sales channels, offered both to inquiring customers and generally, easy to locate, clearly labelled, and there would be consumer-facing information regarding their existence or use. And then a comparison is drawn with off-peak fares. Now, they cross-refer to the amended claim form. We should have a look at that. If we go back to that, it's in the core bundle. Forgive me, it's in the same bundle, I think, at page 37. And we see at paragraphs 38 to 40, where it's alleged in the reply that the counterfactual is clearly articulated, there is a reference to a mystery shopper study by an outfit called Decidedly, a research specialist called Decidedly, and they say that the key findings, they say, are that availability varies by sales channel. And they say in A(1), boundary fares are in principle available at station ticket counters, over the phone from the first proposed defendant's customer services, and from the first proposed defendant's own TVMs. So a rather important acknowledgement that, in fact, boundary fares are available at these important sales channels. And I'll come on to show you in a moment quite how important those sales channels are. So they are available at station ticket counters from TVM, ticket vending machines, and over the phone. Then they say they're not available on online platforms, and they're not available from third parties. Now, what is clear from all of this is that the allegation is no longer, certainly now clear beyond any doubt, that the obligation is not to, as it were, foist upon all eligible customers a boundary fare. Rather, it was just an obligation to make such fares more widely available and to publicise and promote them better. And it is asserted with the likely outcome that this would have led to greater uptake. Now, this recasting of the claim may well make it more defensible on the merits as an abuse of dominance. It may make it less apt to be struck out or summarily dismissed as not giving rise to a claim with reasonable prospects of success. But that recasting also, in our submission, had important implications for the proper quantification of the claim and therefore for the methodology that was apt to achieve that. Now, before I come on to that, it's important just to make two observations about the allegation of abuse as now formulated. Now, just first is this: despite its protestations to the contrary, the claimant does actually make two distinct allegations of abuse. The first is an allegation of abusive unavailability or limited availability. And the second allegation is one of limited promotion or publicity to customers. And it's important to consider which is the allegation that is really doing the work here. Now, let's start with the allegation of unavailability or limited availability. The fact is that boundary fares have been by no means unavailable. On the contrary, the evidence is actually very clear that anyone who wanted to buy a boundary fare could have done so relatively easily. There was not a serious availability issue. Let me show you, to make that good, you've seen already the pleading where their own survey shows the availability. Let me show you some of the uncontradicted evidence.
Can I just understand what the legal relevance to this is? We can't obviously make any factual findings. That's for trial. You may be right. You may be wrong. What does it add up to?
I just want to show what really is the core of the abuse here, because it goes to this question of it goes really to the question of what is it when one then comes to quantification. It's just important to bear that in mind as I'll show you. I think you'll see the relevance.
Case, which is set out at you just shown us. I mean, truth is, it says that they are they were available through ticket counters and station vending machines. They weren't available online and through apps.
Yes.
And they weren't available from third-party operators.
Yes.
Like trainline.com.
That's right. And that's...
we don't have, I mean, I don't know if there were statistics before the tribunal as to what proportion of ticket sales in a modern context are purchased online, but I rather suspect that a good deal more than 30 years ago.
Well, my lord, let me show you the evidence of that, because it's rather surprising in relation to the relevant period. Could I show you, Mr.
Your point ultimately is methodology must match this, you would say, evidentially uncertain picture.
That's right, and also
the underlying point.
It is, my lord. That is it, and also it's got to match the fact that this abuse actually is and as I come on to this point in a moment, it is essentially a range. It's really what they're saying is the abuse consisted of this whole series of different types of behaviour. And one has to bear in mind that when we say, of course, none of that amounts to an abuse. This is actually just a consumer protection case dressed up as a competition case, and none of it is abusive. But we also say that you have to bear in mind when it comes to quantification that this is on any view a vaguely pleaded abuse with a range of different types of omission, effectively, that are pleaded as constituting the abuse. When the tribunal, if it finds an abuse, can find an abuse in different varying forms, and that will have implications for the plausibility of the assumption, which I'll come on to, on which the claimants rest their methodology. We say it is just an assumption, and our key point, it was an unwarranted assumption. It required a proper methodology in order to ascertain uptake. And therefore, I think it is important not to proceed on the assumption that somehow, well, ticket vending machines don't matter and so on, because it wasn't on the website. On the contrary, if I could show you the evidence in that regard, it's in the first supplemental bundle, and you'll see it in the statement of Mr. Cameron at 257. And you'll see in paragraph 23, rail fares can be purchased via self-service ticket vending machines, ticket counters at London Overground, transport for London Rail and National Rail stations, telephone call centres, websites and apps operated by operating companies, website and apps operated by third parties, travel agents and travel management companies, and on trains or platforms. The majority of First MTR's products are sold via station ticket counters and TVMs, although this is in gradual decline with the increase of website and application-based sales.
Could you give me the paragraph number again?
Forgive me, my lady, it's paragraph 23 on page 257.
I haven't got the page.
And then you see he goes on to give, he gives confidential information there, which I won't read out. But you see the statistics on the earnings, and you see the statistics that very much back up the proposition that actually the outlets that matter in quantitative terms are the TVMs and the station ticket counters in the relevant period. And if one goes on to paragraph 55 in the same statement, which starts on page 269, he says, I note that the proposed class representative accepts that boundary fares for South West Rail franchise are available through the following sales channels: station ticket counters operated by TOCs, the vast majority of TVMs operated by First MTR. I know the boundary fares are available at approximately 84% of them, limited TVMs operated by third parties, and First MTR's telephone call centres. So when the claimant says boundary fares are insufficiently available, that's a difficult allegation in some ways to understand, at least as regards First MTR, because they are available at the main channels through which the vast majority of its tickets have always been sold. And really when it comes to the allegation against First MTR, the availability allegation is at most that they ought to have also been available on the website, and ought to have somehow been, First MTR was somehow liable for the acts of the third-party vendors. But the website at the relevant time was a relatively minor sales channel. And
That's because we're going back to 2015, is that the point?
well, it's the period of the claim. Yes. And the important point to bear in mind also, and this is a point that I think is very important and not to lose sight of, is that there was available to passengers also an almost perfect alternative to boundary fares that was available from any sales channel, including the website. And that's because even if a boundary fare as such might not have been known to a passenger, it has always been perfectly possible for almost all passengers to achieve the equivalent of a boundary fare. And the way they can do that is simply by buying point-to-point tickets from any of these sales channels, from the last station within the relevant zone. So the passenger
How many
simply,
people do that?
well,
I know it's been hawked on television in some of these consumer protection programmes I've heard being referred to, but is it? I don't think I've ever been savvy enough to do it.
Well, it's incredibly simple. All you do is you use your travel card for the first part of your journey up to the last station in the relevant zone. And then you buy a ticket from that station for the remainder. You don't have to get off at the station and buy the ticket, because you can buy the ticket on the website, or indeed from any station, because you can get a ticket at one station to depart from a different station. So you can create a boundary fare equivalent with a point-to-point fare. So just to give a simple example, if you've got a travel card and you're travelling from Richmond to Southampton Airport, for example, via Clapham Junction, the passenger can go on the website, you buy a ticket from Clapham Junction to Southampton, to the airport. You then, or indeed you can do that from Richmond Station, if you so wish. You then embark at Richmond, you use your travel card. If a ticket is requested by a ticket inspector up to Clapham Junction, you say, well, here's my travel card, I've got the right to travel to Clapham Junction on the travel card. And then for the rest of the journey to Southampton, you use the ticket. So it's really not. This is not a complicated process. It just involves you using your travel card and then buying something from the station. And if I could show you the evidence on this, again in Mr Cameron, we see it in paragraph 31, which is on page 259. Perhaps if I could just invite you to read, just to verify what I've said, paragraphs 31 to 33.
I think it would be right to say that if you're buying your ticket at a TVM, it doesn't say, you know, as you sometimes you pick your destination. Point 2 is, have you a travel card? Yes, no. Yes, 3, this is the price. So it only then charges you from the end of the boundary, from the boundary fare point.
Yes, if you
you've got to work it out yourself.
well, you just have to know what your travel card entitles you to do, and then you and if you're the point is this, that if you're a regular customer and you're conscious
No, I
of your
understand the point.
expenses, I mean this is the way to deal with this. And
your point is at highest at a point of transparency.
yes, Michael, exactly, and that's why this methodology is defective. Really, so it's an important part of background why it's defective. If one goes on to Mr Joyce's statement, which is starts also in the same bundle, and if I could just invite you to really look at the same point, he makes the same point, page 335, paragraph 41. And if you also read paragraphs, I also invite you to read paragraphs 43 and 46.
Yeah, 43 and 46.
41, 43 and 46.
So your point is it's not availability, it comes to their second limit for their alleged abuse, which is ease of access.
Well, or as I think I would
Perhaps
put
another
it,
way of saying
publicity.
transparency.
I think I would put it as publicity. It's all really about. It's all about.
It's educating the consumer to make
Yes.
a choice.
Yes, that's right. Publicising the availability of these methods. I should just show you for completeness that in relation to this point about point-to-point travel, the tribunal was also obviously a bit concerned about it, because you see that they deal with it. If you go back to their judgment, paragraph 126, we see that in the context of adverting to the inadequacy of Mr. Holt's methodology, we raise this point and you see, or LSER, Harris's clause raised the point in 126. You see this the third bullet in 126. Another point-to-point ticket from somewhere in the outer zone of the validity of the travel card to the destination may have been cheaper than or the same price as the equivalent boundary. And if one goes to the judgment at 132, We see the tribunal says, however, we do see that there's a significant issue regarding so-called point-to-point fares. Example 3. Passengers who bought a point-to-point fare for the portion of their journey between the last station covered by their travel card and their destination substantially mitigated their loss and or may have avoided their loss altogether. In particular, they avoided paying twice for part of their journey, which is the complaint underlying the claims. Accordingly, we think that travel card holders who purchase such point-to-point tickets are in a materially different position from other members of the proposed class. So the point for present purposes is just this, that this isn't, as I said, this isn't about availability. You can either get, you can
They
basically...
then go on to say that they,
Yeah.
in 133, they don't think it's likely to be a very large number of people.
Yes, and there's no...
Because people don't necessarily know what the last station on their
Well,
zone is.
I'll come back to that, because in our submission, neither of those points holds any water at all.
But you've got to help us with this, that this is the CAT's assessment. They may be wrong, and you may prove your case at trial. But are we in a position to challenge the CAT's evaluation of the evidence at the certification stage?
Well,
And that's entirely without prejudice to what may be the merits or lack of merits at the point at trial.
well, when they're manifestly wrong, you can, and or inadequate,
Okay.
manifestly inadequate, and I can show you briefly, if you wish, why these 2 points are manifestly inadequate.
But you accept the challenge of a relatively
No,
high
I
standard of
absolutely,
appeal.
and I will, and I let me show you why they're inadequate. The first point they say is we note that until the conditions of carriage were amended with effect from 1st of October, a point-to-point fare could be used in combination with a travel card only if the train stopped at the origin station of the point-to-point fare. Okay, well, there are 3 points why that can't be a good reason. First of all, it's 1 year. It only amounts to 1 year of a 7-year claim. Okay, so at most it's valid for 1 year. So that in itself really means that this is a de minimis, as it were, objection to the point. Secondly, actually the evidence before the tribunal, which I can show you from Mr. Joyce, is that actually it could actually be used even if it didn't stop, even for that 1 year, if you had a travel card that was 7 days or more. So in fact, it's a more restrictive point even for that 1 year. And thirdly, most commuter trains stop at least one zonal station. So that first point is just a non-point, clearly. Any one of those 3 reasons, but certainly the 3 of them combined. And the second point they mention is that they needed to know the identity of the last station of their journey covered by their travel card. I mean, really, you just need to look at your travel card to know what. But
No, you don't. That's not right, because your travel card doesn't even say.
well, you
You would need a map. You would need something that told you where the zones began and ended.
well, yeah, that's fair, my lady. But it's not this is not something that is difficult to find out in any sense. It's not about availability.
But the upshot of all this is that even though, despite their suspicion that it's not really a very big category, they say, well, it's been excluded anyway.
Well,
so Mr. Moser agreed to it being excluded. So this is
Lord, yes, but
tilting at a windmill, isn't it?
well, my lord, it's not, and for this reason, that for 2 points. The one is that I'm making this point in the sense that, first of all, is there really unavailability? This is, and there isn't really unavailability because you can get an equivalent. The equivalent is available. So that's the point for which I'm addressing you at the moment. But also, despite the fact that Mr. Moser accepted that the class definition can readily be amended accordingly, we don't accept for 1 minute that there is a method by which you can readily extract these point-to-point fares, because you simply don't know, and the evidence was clear on this. You don't know whether somebody who first buys a ticket from Clapham Junction has used their travel card to get there. You simply don't know that. And the only method that's suggested to try and figure this out is a survey, as Mr. Harris says. Well, that's not a method. That's just a typology. One has to see how on earth are they going to quantify that? And there's just no basis for this. You can't, as a tribunal, you can't say we suspect it's unlikely to be a large cat. That's not enough to say that somehow it can be waved through and assumed in our submission. So
A really big issue in this case is to what extent the cat is entitled at this stage to make assumptions, even if they're fairly rough and ready, or alternatively the extent to which they are required to have a much higher degree of evidence to a much deeper level of granularity. I mean, quite what the burden on the cat is at this point is
My
quite a
lord,
big issue.
If you're right, then there should have been a much greater degree of, as my lord puts it, of granularity at this stage by the cat. And effectively, on the Tox case, this is completely unsustainable at any stage, because nobody's ever going to come along and ask to have their £43.50 back over the last 5 years or whatever it is. I mean, as you've just demonstrated by saying, well, who are these point-to-point people who purchase point-to-point fares? Is anybody?
well, my lord, but this is the question.
I just don't know.
The question is whether these cases, which should be I mean, the tribunal finds on a cost-benefit analysis that it's not. This is not a claim that's worth the candle, and that's.
That's
and
your
that-
case. That's
well,
your
that
case.
is, well, that's the tribunal makes that as a finding. It says
No,
it's
I
not.
understand
It
the
says that
Not quite in those terms.
No, not right. But it says that the costs exceed
It's
the
a more
benefits.
nuanced analysis than that.
It does.
Mr. Chappell.
It does say.
It's a factor in all these consumer claims that you've got small claims
Yes.
with very high costs of enforcement.
Well,
And
that's
that-
right. But that's why you do have to have this gatekeeper role. So we have to
Absolutely.
say that, and I'm going to come to the central
Well,
point. which
as
is-
my lord says, the
Yeah.
very important issue for us is how far does the cat have to go?
well, I quite agree, man.
And you say it has to go
I-
to a much greater extent, as it were, than it did.
I'd say just this. You have to have a complete methodology. You cannot just say for one step in the chain, we make an assumption. We just assume, we just wave through. And then it's not just some sort of minor point, which is going to go without saying. This is reliance and causation. This is actually the very heart of the case. And that's what I'm going to come on to that momentarily. But I just want to make one final point about the nature of the abuse before I do.
Would you go so far as to say, I'm just trying to make sure I've framed
Yes.
it right, methodologies cannot rely on assumptions?
No, of course I don't. But I do say this, that you cannot, what you cannot do is say that the whole issue, it's always fact dependent, and there will always be some assumptions. I accept that. But what you cannot do, and it's always a matter of fact and degree, have to accept that. But what you can't do is say that the whole central issue of reliance and causation, we're just going to assume. We're just going to assume it's 100% reliance and causation. And insofar as you say that there are some points that clearly we have to deal with, well, we will do a survey in due course. It's completely unspecified, completely uncosted to deal with those issues. That, we say, isn't enough. That is not a meaningful gatekeeper role. So I just want to make, before I come on to that central point, is, as I said, the abuse really, the heart of the abuse is really this question of lack of publicity. And by its nature, there are a variety of ways in which that abuse could ultimately be framed and ultimately be found to exist, if it exists at all. And on one end of the spectrum, of course, you've got the possibility that the abuse was no more than not making boundary fares available on the website and not putting a sign up saying, don't forget, you've got the right to a boundary fare ticket. Another possibility at the other end of the spectrum is that the salesman, the ticket salesman and the vending machines all have to have engage, as they put it, engage actively, interact with every customer, even though only a tiny proportion of customers are going to be affected by this, maybe 1 in 20, if that, on Mr. Holt's analysis. And then you have to engage with every customer and say whether they've got a travel card and whether they're entitled to a boundary fare. And bear in mind that, and that I think is the high point that's the highest point of the claimant's case. They say there has to be this general interaction. But if that's right, one has to bear in mind that's a lengthy process, because it's not just a question of saying, do you have a travel card? You have to say, do you have a travel card that's valid for the relevant period of your travel? You have to say, do you have what are the zones for which your travel card is valid? And you have to know, if it's an open return fare, whether when you're coming back, whether the travel card is still going to be valid for your return journey.
But aren't those all matters which are for the consumer, for the passenger? And what's said is that in your example, that the person at the ticket counter should alert the passenger to the availability of boundary fares if they've got a travel card.
Yes.
And then it's up to the passenger what they do about that and whether their travel card is valid.
Well,
so the idea
yes.
that the person at the counter is
Yes.
going to be engaging with each customer on boundary fares for 5 minutes is unreal.
Well, I respectfully agree, my lord. I say that's not I don't know we don't know precisely how they put their case, but there are difficulties.
And on a ticket vending machine, I mean,
Yeah.
I think my lady made the point that what you'd expect is that when you feed in, you get asked the question, do you have a travel card?
Yes.
You say yes, and then it alerts you to the possibility of saving money by buying a boundary fare.
Yes.
And if you choose to take it, that's a matter. Whether you choose to take it and go further is a matter for you.
Well, my lord, it's not that simple, because if it alerts you to the possibility of buying a boundary fare, and then you buy one, but then you're not valid for the right zone, or it's not valid for your travel card isn't valid for the right period, then there are going to be all sorts of consumer issues there. You can see people getting tickets which are invalid in those circumstances, and then having to go and get a refund and paying the cost of the refund and so on.
That just means you've got to enter on the machine the correct descriptor
Yes.
of your travel
Yes,
card.
so you'd have to. The point I'm making is that if you're going to start to, these are complicated questions about website design.
Were there statistics? I'm sorry to interrupt you, Charles, but were there
Yes.
statistics before the CAT about what proportion of travel cards were for zones 1 and 2, and what proportion were for the whole system? Because an Oyster card, from recollection, an Oyster card will take you to through the whole of the system, right the way through to zone 6 or whatever. So in your example, you can travel from Waterloo to Richmond
Yes.
on an Oyster card. You want to go any further than that?
Yes, but there also one also needs to bear in mind. Well, my lord, yes, that's possible. That may well be correct. I can't recall now which, but there is evidence, yes, about. But the only point I make is that there are clearly different cards for different zones. There are many variety of travel cards. There are ones that are off peak. There are those that are only for 7 days. There are those for 1 day. There are those for a month. There are those all of these questions, before you can know for any particular journey whether you can get a boundary fare, there are potentially a lot of questions down a sort of tree diagram, effectively, that you would have to go through. Now, whether you do that with the ticket collector or on the screen, I'm told, my lord, that an Oyster card is different to a travel card. The abuse does not relate to Oyster cards.
A travel card is some form of prepayment card. That's the essence of it, is that you paid for a day or a week or a month, whether you're an old age pensioner or you're just a normal person.
So the travel card can still, I mean, my example will still be correct in the sense that you can buy a travel card for
On your Oyster.
the whole system.
Yes, you can
And
buy
you
it for
hold it on
76.
an Oyster card, so your travel
Yes.
card might be on an Oyster card.
Yes, that is
But
correct.
an Oyster works in a multiplicity of
Yeah.
different ways as well. That you can just put cash on it, can't you?
Yes.
Just tap in and out. In which case, it wouldn't. As I've understood it, it's not a travel card if that's how you use it.
Yes,
A travel card that's the whole point, isn't it? You prepaid
You
for the journey
prepay, you don't
by
have to
your
pay as
travel
much
card.
money.
Yes, my lord, that's correct. That's right. But the essential point is that this is, and it's very important not to think that this can be done in an easy fashion.
I'm not certain about that. I'm travelling London to Edinburgh. Tell me why this is wrong. So I put in the destination, the TVM, just Edinburgh,
Yes.
and it then tells me, have you got a travel card? Press Y for yes. Then it gives me the different types, and I click on the type I've got, and then it just gives me a price.
Well,
Why is that complicated?
my lord, it is
Which
quite-
includes the boundary phase.
because you've already you've got to put in when is what is the period of validity of your travel?
That will be day pass, weekly pass.
Well, but there's also a question: when does it expire? If you're on a return journey, is it going to still be valid for your return journey? There is a rigmarole that is going to have to.
Rigmarole or
Well, it is.
options?
There is a complexity and a time associated with this process. Right now, there's no doubt.
At trial, the tribunal might say that's absolutely right. This is your perfect answer to the question of accessibility.
My lord, we're confident they will. Actually, one of the reasons we believe they will is because when you look at the way the website is designed, particularly, is it's designed around the time of travel and not origin and destination, which makes it particularly difficult to
It
then
deals with off-peak
graft onto.
savers now, doesn't it? You have to get it right if you're going to the machine. You've got to be careful. It tells you you can only travel on limited trains if you buy such and such a ticket.
Well, this will all be the subject of evidence. My only point is that there is some complexity here. There is some time that will be required on any view. There are clicks that will need to be made, information that will need to be added on that, and that.
But I mean, I don't
Yes.
travel on your clients' services very often, but I do travel on Great Western Railway every week. And when you feed into the website, you ask for a ticket on the website. One of the first things it does is ask you whether you've got a travel card. It then gives sort of 20 different options, and you have to click on the right one.
Yes. Right. Yes.
I mean that picks up my lord's point about you don't need to be a rocket scientist to work out what sort of travel card you've got.
Well, but no, I accept that. But you do need to then input all that information. You need to go through.
If at the end of the day, picking up your point about is it valid, it turns out your travel card wasn't valid for that journey, well, then you're going to find yourself in stuck when the ticket collector comes on and the ticket inspector comes on and asks to see your card.
Well, my lord, you are, and that's why it's very important that there shouldn't be too much complexity, and that these interfaces should be user friendly. But and this isn't and
Anyway, I think
yes,
we've sort
yes,
of
but the
gone
only,
around
the
that
only,
particular.
yes, by my lord, yes. The only point I'm making is that if you take the extreme form of the abuse, if you like, that you've got to go through all of these. You've got to very much introduce this very much to the customer's attention. It's a process that's going to take some time and some complexity, however well it's done. That's the only point I'm making.
And just so clear,
Yes.
at trial, the first question for the CAT will be, what is the abuse? And it's only once they've identified what the abuse is, you can then work out what the counterfactual is and work out your causation and quantum on that predicate.
Well, my lord,
Because I think your point is that you've got to define the abuse before you can define the counterfactual for the purposes of causation and
my lord,
liability and quantum.
that's right. Well, unless one did it on multiple bases, but yes, essentially yes, my lord, and that's rather important then, when it comes to what should have been certified here. But anyway, the
Well, the CAT doesn't know at that stage precisely what it will find at trial, and
yes, but then,
absent a strikeout is not even meant to look at the merits. So
well,
there's a limit to what it can speculate or postulate about.
well, my lord, that is fair. But then it should not be saying this is suitable for aggregate damages. It should not be saying this is certified for causational reliance as well. That then is the proper approach.
And that assumes, I'm sorry to keep, but that
Yes.
assumes that the definitive decision about aggregation must be made at the first stage. And it's a binary, it's a yes or a no, and you can never ever change it, or you can never adjust it as time goes on. You can never modify to take account of changing circumstances.
I don't say that it's implicit in that. I simply say that if you can't be confident, because no methodology has been presented to you, and indeed the abuse is too nebulous at the present stage and unparticularised, you should not be certifying causation and reliance as a common issue. You should not be saying that this can be resolved by an order of aggregate damages. And my lord, just for completeness, Mr. Holt's first report shows data on TfL travel card sales by reference to different zones. For your lordship's note, that is supplementary bundle 2, page 416, table 6.6. So I then come, if I may, to the central point and the failure to articulate the methodology. And what the claim does is to proceed on the basis of an assumption. And one sees the assumption at page 53 of the supplementary bundle, at paragraph 111 of the claim form.
Sorry, can you give me those, what am I
Yes,
looking at again?
it's supplemental bundle 1, page 53, paragraph and 111.
Thank you.
This is in Mr.
This is the claim. And you see they say at paragraph 111, the class members have overpaid because of the proposed defendant's conduct which constitutes the infringement. It is implausible to assume that class members would have willingly paid twice a part of their journey had the proposed defendants taken sufficient steps to make boundary fares available and to make customers aware of them. The issue of causation, therefore, is the same for all class members. Now, that is, of course, rhetorically clever, and it is superficially beguilingly attractive, but it is also, in my respectful submission, on closer consideration, completely unwarranted. And to see why it's unwarranted, we should just consider a few points. First of all, there's the amount of potential savings that are involved here. Now, according to Mr. Holt, the average value of the savings per journey is about £5. But there's variability around that. So, for example, he acknowledges in footnote 220 of his report, you don't need to turn it up, but footnote 220, he says, well, in some cases, the boundary saving would be 0 because the stations are grouped into clusters. And let me show you a sort of typical example that Mr. Holt himself gives. It's on page 426 of the second supplemental bundle.
426.
Yeah. And he gives the example here of Clapham Junction to Raisbury. And we see that he suggests that the average saving of using a boundary fare here would be £2 and 7 pence. But you also see in the table, you see in the left-hand column, that on specific routes, it's much lower. It's as low as 40 pence on some savings, on some routes. So there are very small savings indeed in a large number of cases, in many cases. Now, the second thing is that, as we've already seen, is that many people who own a travel card or are regulars are going to, surely, we say, be aware of the possibility of using a point-to-point option. Others who are not regulars will often be in a considerable rush. I think that you're entitled to take judicial notice of the fact that people travelling at train stations are often late. They are often in a considerable hurry. And so one can immediately see a number of good reasons why a customer, even if there was greater promotion of boundary fares, and even if the boundary fare was a fraction cheaper, might not in practice buy one. If it transpires that the abuse, for example, consists of just putting up signs on the ticket offices and making things available on the website, the individual might not notice the signs. They might not visit the website. If the abuse consists, as we've discussed, in a series of click-throughs that are necessary before you get this slight saving, many people will just say, well, the kind of saving we're talking about here, it's the price of a cup of coffee or a fraction of a cup of coffee. And I don't want to go through the rigmarole of clicking through.
But
all
aren't the
of
majority
these.
of people who are in a rush, I mean, I follow the point, there must be some force in it, but if you start thinking about it, why, people who are late for trains are usually people who already bought a fare previously, either on the internet or whatever, or they've got a travel card. And the reason that they're not buying the fare, most of them, at the station, because by definition they've turned up late to the station and they've already got a ticket. Because if they haven't got a ticket,
Yes.
then they're going to need to buy one when they get there, and however much of a rush there might be, and they'll miss that train and get the next one. So I'm not sure that people being in a rush as such
Well,
really gets you very far. I mean, I follow your first point about well, some of these savings are infinitesimal, and indeed, Mr. Holt's table shows that some of them actually the boundary fare you pay more. The red ones, as I understand it, you're actually negative savings.
well, my lord, actually, the evidence before the tribunal, before this court, is that advance sales are a small proportion of sales. There's always a difficulty of extrapolating from one's own experience.
No, I'm not thinking of advanced sales. I'm thinking about people buying, even people buying tickets at the station.
Yes, but most people, as you've seen the evidence, is that the vast majority of people in the relevant period bought at the station ticket vending machines or in the counter, not on the websites, and one would normally think were people at the station. Now that may be. This is the reality is that it's rather like to some degree it's a matter of personal predilection. I mean, it's rather like not everybody uses loyalty cards. I mean, a cup of coffee at Costa Coffee, I think, costs about £3.50 or so. So if you have 10 stamps, you're saving yourself 35 pence a coffee if you get them. But not everybody takes the loyalty card.
That point is
Yes,
well made.
Yes, not everyone. Not everyone.
Not everybody can be bothered.
Not everyone can be bothered, and
Or
that
they haven't got their card, or they can't find it.
absolutely, exactly. And
But
it's rather
aren't
like
these all issues for trials.
if they, but there has to be a methodology for trial. What they had to do was to say we have a methodology to measure increased uptake. They didn't come with one. They just said assume it, assuming everybody, assume 100%. That's what they said in their claim form, and that's.
If you start with an assumption, it doesn't prevent the defendants then saying, all right, this assumption is an overgeneralisation, and we've now put in evidence to demonstrate that in X percentage are point to point, another percentage are rushed or regular, another percentage are. You can debunk that assumption so that it is actually whittled down to, instead of 100%, to 60% or 50 or 40.
The problem with that,
What's the forensic problem with starting with an assumption?
There's an important point of principle here. It reverses the burden of proof. They say we start off with an assumption of reliance, of causation, and then it's for you now go ahead. And that's exactly what the tribunal did. They said, no, well, you can go and whittle it down. You can find the method. That's not for us. That's for them.
But that's only right if
you're
right that the assumption is wrong.
Well,
if the assumption's correct, that doesn't prevent you from whittling it down and having a tussle about the evidence on both sides.
The assumption we say is not on any view is not clearly warranted in many cases, and that's enough to then, in our submission, to throw the evidential burden on them to come up with a method to measure the extent of uptake. Not just assume it. Now, interestingly, the existence of the consumer apathy, if I can put it that way, in relation to these sorts of issues of small savings, is actually, funnily enough, is rather well evidenced, as a general matter at least, in another passage in the judgment. Because if you go to the judgment at paragraph 174, when they're talking about uptake of class action awards, it's page 199.
Yeah.
one sees that the evidence is that take-up is very low. They say the limited examples suggest that these tend to be cases where class members are written to. They say that nonetheless there are cases where even small individual entitlement attracts significant participation by class members. But the limited examples discussed in those notes suggest that these tend to be cases where class members are written to directly and virtually no verification is required. And then you see the example of the Levi Strauss case. So they say maximum recovery, $2 per pair of jeans purchased. 14% to 33% of class members applied for refunds. So that's what's regarded as a high figure for those sorts of claims. Now, if that's true in the context of people being written to for class action, there's no reason to suppose a priori why it isn't also true when it comes to these sort of small savings on fares. It's rather like saying that everyone takes back the trolley to get the return of their £1, or everyone uses a loyalty card. Some do, some don't. And what's required if you're going to make an allegation of more publicity is a method then as to how you measure that, what the effect of that's going to be. Now, there are other reasons, more specific reasons, why otherwise eligible customers might not purchase boundary fares, even if they'd been better promoted. And one instance is that which is noted in Mr Cameron's statement in paragraph 60F, and I just give you the reference. It's in the supplemental bundle, page 277. And that is where the person their travel is expensed. So in other words, they're travelling on work. One would expect that to be a rather large proportion of travel. Now, if one pauses, travel cards generally, I think one could take judicial notice, they are a means that people use to commute. They are owned by people personally, in their personal capacity, not provided by the employer typically. Now, one can well see that if an employee is travelling and their expenses are paid by their employer, they don't necessarily consider themselves legally or even ethically obliged to go out of their way by combining their personal travel card to obtain a lower fare. And added to that, of course, as Mr Cameron noticed, it may well complicate matters for the employee when it comes to claiming back the expenses on the corporate system. So they might have to field time, fielding questions from HR saying, well, you're meant to be travelling from Liverpool Street, but this ticket you want expenses paid on talks about Zone 6. So why is that? What have you been up to? So, and there's simply a very plausible case that people who are travelling on expenses will typically not use their travel card to obtain a boundary fare, even if one is available. Now, another possibility is that a person may simply not have their travel card on them when they are travelling on the train. And it's not in dispute that it is a reasonable and non-abusive requirement to insist that a passenger that wishes to use a boundary fare must have a travel card at the time of travel. And if you've left it at home, you can't profitably buy a travel card, buy a boundary fare, even if you have a travel card. And another possibility is that someone buys a 7-day travel card, but they're planning to return on a date when their travel card has expired. So if you're returning on that date, then you can't buy a return boundary fare. And you'll see that possibility is referred to in Mr. Cameron's statement of paragraph 60D. And so if these look like remote examples, they're absolutely not. And let me show you Mr. Holt's evidence, where he seeks to identify the types of customers that he hypothesizes might be harmed by the abuse. If you take up supplementary bundle, the second supplementary bundle, on page 427.
Yeah.
And here we're in step 3 of Mr. Holt's analysis, where he's establishing whether harm has occurred, whether a passenger taking an in-scope journey held a travel card. And he says 6.2.58, he says, harm may arise for a variety of reasons, such as, and he gives 3 examples. The first example, he says, is a London commuter is required to travel outside London for work, but nonetheless carries out frequent within London travel and therefore holds periodic travel card. Well, that's the example I've already given you, travelling for work. We're not many people will not plausibly buy a boundary fare just to assist their, save 40 pence or £5 for their employer. And the second instance he mentions is he says a London resident takes a weekend trip or holiday out of London by rail. Well, I suggest if you're going to Cornwall for a weekend, a typical time you might not have your travel card with you. So again, an instance of when one wouldn't have availability. And finally, he says his final example. He says a tourist has purchased a travel card and wants to visit a nearby town or city. Well, if the tourist is a foreign tourist, they're non-resident, so they're not in the opt-out class anyway. They're going to have to opt in. And frankly, I mean, the possibility of one getting any material numbers of foreign tourists opting into this class action are surely remote, to say the least. Now, could I then turn to the tribunal's judgment to show you how they have dealt with it? We start with paragraph 126. Yes. And we see here they advert to the various examples, most of which that I've given you already, and some of which I'll come back to. And then in 128, we say that they talk about they talk about the example of not having the travel card with you, and they say. They mentioned that they say if that was a requirement at the time of purchase, that itself might be abusive. But then there's the question of, well, what if they simply, as I said, when you go to Cornwall, you don't have your travel card in your pocket? And they say, as regards the latter, it's of course the case that some passengers will forget to bring their travel card, but if boundary fares were widely offered, the consequent increase in customer awareness suggests to us that this would not occur so frequently. Well, that may be, but it does not diminish the point significantly. Remains a reason why there would not be 100% uptake. You then see that's really just pure speculation. And then in paragraph 130, which is example 6, which is a point that we've discussed at some length, which is that the passenger may not have had the time or inclination for a very small absolute saving to devote any extra effort to choosing and buying a boundary fare, for example, because they were in a hurry or were going to be reimbursed anyway, bearing in mind that the proposed class includes business purchases. They just say this, well, we think the numbers involved are likely to reflect the degree to which buying a boundary fare involves extra effort, and that itself relates to the alleged abuse. Well, yes and no. There's always going to be a degree of effort involved, as we've discussed, in buying a boundary fare. And they say, well, the unavailability online may be a disincentive. They say they consider that don't they consider this aspect undermines causation of loss? But with respect, it does undermine causation of loss. It clearly undermines causation of loss for many, many prospective travellers. And then in the final example we gave, they may not have cared about price optimization to begin with, for a small absolute amount, or if being reimbursed. They say in 131, we recognise the possibility, but suspect that the numbers involved are unlikely to be significant. And then they say this is a matter which can be established subsequently by the customer survey, which Mr. Holt proposes to have carried out. Well, the tribunal's suspicions that the numbers are unlikely to be significant is with respect neither here nor there. This is an issue, and it requires a means of resolution and quantification. They similarly they see. We've already discussed the paragraph 133 on the point-to-point fares, where they clearly give a number of reasons there why they aren't important, which are clearly manifestly wrong in our submission, which I've already taken you through. And there's simply no method identified about how these exclusions are going to be carried out, other than this reference to a completely unspecified survey. And I should add that there are also other ticket types, notably promotional fares, such as group fares and advance fares, that were frequently cheaper than boundary fares. Now, the claimant advances this rather hopeful allegation that it was abusive not to sell boundary fares on top of some of these discounted fares, such as advance fares. And Mr. Harris has already made the submission as to why that is not a sustainable, plausible allegation of abuse. But even the claimant must accept that some of these fares, and I think they do accept that some of these fares, are not going to be eligible for a double discount, such as, for example, Kids for Quids, which was a promotional item, or if one takes, and some of them obviously don't work. So take, for example, the group ticket discount. How does that work if one person in the group has got a boundary fare? It plainly doesn't work, because you can't say that the boundary fare of one person in the group entitles everyone in the group to, forgive me, one person in the group has a travel card.
Yeah.
Clearly then you can't then expect the group discount to apply to every, the boundary fare to apply to everyone on top of the group discount. And if one person alone has the boundary fare, that doesn't work, and that then takes them out of the group. So you can't. There are bound to be instances also where the availability of promotional fares also means that the boundary fares are not going to be even cheaper. And again, we say that this wholly notional survey, by which Mr. Holt proposes to extract these, doesn't do the job. And the critical point really is just this, that there's no suggestion by Mr. Holt that a survey could estimate the overall extent of greater uptake that it is alleged that greater promotion of boundary fares would lead to. At the very best, a survey is going to be a rough and ready way to extract some particular fare types from a baseline assumption of a 100% uptake. And as I've said, that reverses the burden of proof, because it throws onto the defendants the burden of disproving reliance. And that is also unjust, and it will lead inevitably to overcompensation to the claimants. So if I may then, in the next section, come to the judgment, the key sections of the judgment, where we say they erred. And if I could show you paragraph 157, which is on page 193. And they record our submission that Mr. Holt's method addresses quantification on the basis that every passenger making an in-scope journey who held a valid travel card but didn't buy a boundary fare has a claim. It therefore brings back effectively a strict liability approach which the applicant had disavowed. Or put another way, it assumes that all failures to buy a boundary fare give rise to damages. And we see the answer. We say, as regards the first objection, we don't consider that Mr. Holt's method rests on assumption of strict liability. That's to say that respondents were obliged to sell a boundary fare for every eligible journey. Respondent's argument essentially concerns causation. Mr. Holt has approached quantification on the basis that in the counterfactual, where boundary fares were widely available and offered, passengers would have bought them for eligible journeys. Well, pausing there, yes, he's approaching it on the basis that in the counterfactual, all passengers would have bought them for all eligible journeys. And then the tribunal goes on. It says, that is not a matter for expert evidence, although Mr. Holt's survey may assist in testing it. It reflects the way the applicant puts forward his case, contending that the overwhelming majority of passengers wouldn't choose to pay more for a train journey if offered the opportunity to buy a cheaper ticket. So we say they've just bought the claimant's rhetoric, hook, line, and sinker. We say this was a matter for expert evidence. It required.
I mean, that's not the logic of this paragraph. The
Well,
paragraph is really picking up merits about the cat's ability and right to make what is described as informed guesses.
Well, it goes on to it talks on about to refer to Lord Briggs's observation that the court sometimes has to make, and I was going to come to that. They say this: the respondents are of course free to contest that assumption, but we consider that the applicant is entitled to advance it. Well, we say, in fact, this was a matter either for expert evidence or it requires some other methodology for its resolution. We make no criticism of Mr. Holt, I should say, because his report makes very clear that he was instructed to quantify the claim on the assumption that every eligible passenger would buy a cheaper boundary fare. That's an assumption he's told to make. And the tribunal suggests, well, that's a justifiable assumption based upon this assumption, this assertion really by the claimants that the overwhelming majority of, indeed all passengers, they say, would do so. And we say this is just the wrong way round. It's tantamount to reversing the burden of proof in relation to causational reliance. It's not for us to disprove causation. It's for the claimants to assert it and to prove it. And they need to have, in this context, a methodology to do so. If this was an individual claim, the individual would have to come forward and assert, if there had been greater promotion of boundary fares, I would have purchased them on my journey. And they would have to prove that. And the collective regime, for all else it doesn't reverse the burden of proof. And the tribunal has identified...
Can I just analyse the last part of 158?
Yes.
Should we analyse it as the tribunal concluding, albeit provisionally, that it is entitled to infer that the overwhelming majority of passengers would have bought a boundary fare had it been transparent and available? So that's an inference of fact that they say, and it has probative value because of the law relating to judicial informed guesswork. Well, therefore, it's not a reversal of the burden of proof. It is the tribunal's legal starting point as fact. It's what they've found.
Well, if that is what they're saying, I'm not sure they are going that far. I think it's simply a misunderstanding, really, on the part of the tribunal here of what's required. They've lost sight of where the burden of proof lies in relation to reliance and causation, in my submission. But this is not a finding of fact that the tribunal is entitled to make on an interlocutory basis. If that is a finding of fact.
That's the key to it. It's not entitled to make that finding of fact.
If it is a finding of fact, not entitled to make it. And yes, well, as Mr. Harris reminds me, particularly given that we had uncontradicted evidence on all of these various points, and it doesn't fall within Lord Briggs's observation. That's a different point. Lord Briggs certainly wasn't saying that critical steps in the assessment of loss, such as reliance and causation, can just be skipped over, whether in an individual action or in a collective one. The true import of Lord Briggs's remarks were to the effect that in certain limited circumstances, where the evidence is exiguous, the courts are prepared to estimate matters in a rough and ready manner. But that isn't license for a claimant to just assume that which they have to prove. And it certainly doesn't do away with the requirement under the Pro-Sis test that a claimant in a collective action must advance a plausible methodology to calculate his loss. The broad axe applies to quantification of loss. It doesn't apply to the causation of liability.
Well, that's what Lord Briggs is talking about, isn't it?
Well,
he's talking about broad acts.
Yes. Yes, he's talking about broad acts. He's not dealing with
on causation and reliance.
Causation, exactly. And so we say Mr Holt, the error here, it's not with Mr Holt, it's with what Mr Holt was instructed to do, or rather not to do, because he was instructed to assume reliance. What he should have been asked is, could you come up with a plausible methodology to estimate reliance? That should have been step 5 in his analysis. And now whether he had a means of estimating how many or what proportion of class members would have been likely to buy a boundary fare had matters been more widely promoted, we don't know. But because he simply wasn't asked. Now, as Lord Justice Green will be very familiar, in most competition cases, one looks in trying to deal with this sort of issue, one tries to look for a clean period, as it were, when there is no infringement. And one compares that with the infringement period, and then you adjust for differences. But here there is no clean period, because there is no time when, on the claimant's case, the defendants haven't been abusing their dominant position in relation to boundary fares. There's no obvious comparator. Now, one can speculate how Mr Holt might have said he could have tried to create such a clean period and mount such a comparison, come up with an estimate. And it's not for us to offer methodology to do that. Our point is just that he doesn't do that. There's just a gap in the analysis, and the tribunal's just wrongly glossed over that because it's been prepared to permit the claimants to use an unwarranted assumption in a place of an identified and plausible methodology. And of course, this also factors in when it comes to the other aspect of all of this, which is that had Mr Holt sought to identify a methodology to estimate reliance and causation, he would have then had to factor that into his estimate of loss. So you wouldn't have had a claim of 57 million and 36 million. That would have had to have been discounted by the extent to which there was no reliance, no causation. Now, and of course, I should mention that when it comes back to this, the tribunal, in a sense, it might be said, tries to correct its error or advance slightly different reasoning in its judgment on permission to appeal. And I should show you that. It's in the court.
Can I before
Yes.
you move on,
Yes.
just to take your point forward, do you say that the CAT conclusion in 162 must necessarily be wrong in light of your analysis about informed guesses in 158? The CAT takes the view that it wasn't necessary, in fact it would be disproportionate to require the claimants to produce a survey or survey evidence, even in provisional form, at the certification stage, and it was correct in law to permit them to, as it were, defer it. Do you challenge that conclusion?
Yes, we do. But we also make a more general point, which is that the point of the use that they make of the survey is really to say, well, we can use the survey to, as it were, carve out some, but not all of these many points that you make about why there wouldn't be 100% uptake. Now, we say in relation to that, we say two things, make a general point and a more specific point. The more specific point is the point that Mr Harris has already made, is that it isn't enough just to say we'll get a survey without any specification of the survey. It doesn't enable us to say, that doesn't enable the defendant to say, but a survey can't work for this because, as your own survey expert says, it's going to require a sample of 1 million to work. You can't just gesture to a survey. But then we also make a more general point, which is that nobody has suggested that the survey really grapples with the entirety of the reliance causation issue. It doesn't, for example, really grapple at all. But Mr Holt doesn't suggest a survey could grapple with a point about consumer apathy, with people just being in a rush and saying, well, I'm not going to click through to get a 2-quid saving. What one needs is some actually rather different form of methodology for that, which I've sort of sketched out in broad terms what it might look like. Not really for us to say. But you need something more general.
How much detail do you say the survey would have to go into? And I know, for example, that there was an argument that Mr Harris made to the CAT, which is referred to at 163, about the level of detail required, which the tribunal said was wholly misconceived. So there's obviously a dispute between the parties as to what level of detail has to be put up at the certification
I
stage.
think you need to have an expert. If you're going to say, I'm going to do it with a survey, you can't just say, I'll do a survey, effectively results. I'll do a survey, I'll add a question, and surveys in general have to have these various parameters. You at least have to have somebody who's, you have to, for one thing, you ought to have costed the survey, because there is a cost-benefit analysis going on here. So you ought to have gone to the stage of going to a survey company and saying, could you in theory design a survey to test these issues? And then you should have a statement from the survey company saying, yes, we could, and it will cost this amount. And we'd need to, and broadly speaking, we would expect to have to interview this many people. The sample size would have to be this. Surveys are not an easy matter. But having valid surveys can be extremely burdensome. It's very important to make sure that the survey questions are neutral, not leading. It's important to have a sufficient sample size that's representative and so on and so forth. I'm sure the court knows all of that. And they can be very, very expensive.
And there's no challenge to the proposition or to paragraph 163, as I understand it, which is the CAT saying that the level of detail required for the survey as advanced was wholly misconceived. That was the CAT exercising its judgment over what was required. There's no challenge to that.
I don't go that far. I don't go so far as to say it had to have all of those bells and whistles. But I do say you needed something from a survey expert to say this can be done, and the broad parameters. And in essence, we say that the survey needs to satisfy the pro-sisters. You need to be plausible and credible. If that's your method, you have to say it's plausible. And if just to say a survey is a classic example, actually, of a theoretical, of advancing a theoretical methodology.
No, it's not. I mean, that's exactly the point that they're making at 163, that even the National Rail Survey, passenger survey, only uses 50,000 passengers a year, and they extrapolate the results they get to the entirety of the passengers on the rail network. And that's a perfectly normal method of extrapolating from a sufficiently statistically robust sample.
Well, that it may be, but if one's going to interview...
So taking your example, if you had a survey where one of the questions was, if you'd been in a rush, would you have bought a boundary fare? And you interview, I don't know, 1,000 people, let's just say, and you get an answer, no, I would still have bought a boundary fare from 950 of them. And then you've got 95% of the totality who would have bought a boundary fare, and that's the sort of point.
But suppose that they'd come forward with that proposal, we would immediately have been entitled to say, well, that's obviously a leading question.
All right.
Let's assume it's but you see, the fact is that because there's no specification of the.
Well, what you're really saying, your real submission there is a counsel of despair, frankly, because what you're really saying is you could never have achieved any of this unless each single passenger out of 3 million turned up at court and said, well, under cross-examination, well, I would still have bought a boundary fare.
No, my lord, I don't.
And you'd say to the court, to the CAT, well, believe that if you will, but we submit it's not credible.
My lord, I don't. With fair, that's not a fair summary of my submission. We simply say that it's not enough to have someone who's not a survey expert, Mr. Holmes, coming forward and saying, I would do a survey. I'm not going to tell you anything about it, really, other than its broadest parameters. Yeah. And I'm not going to tell you what questions, all the issues it proposes to address, or what the sample size will be, or what it will cost.
So your real complaint is about the failure to identify what form the survey would have taken.
Anything about the survey. There's simply no evidence from anybody who would do the survey. Yeah. Okay. And we say that isn't enough. We also say that actually Mr. Holt doesn't suggest, for example, that issue of consumer apathy could be dealt with by the CMA. And there's no methodology at all for that important issue.
You were going to show us the
Yes, the
CAT's judgment
the
on-
CAT's judgment on the appeal. You'll see, if one picks it up at, it's in the core bundle at page 217, paragraph 28. And maybe if you could just read paragraph 28. So the first point we observe is that we see that in the third sentence, it will be for the applicant at trial to persuade the tribunal of the extent to which passengers taking such journeys would probably have availed themselves of the opportunity to purchase a boundary fare. So it is there tacitly correcting the suggestion in the main judgment that the burden would somehow fall on the respondents to disprove causation. But then the tribunal simply adverts to a potential conclusion that 85% of passengers would do so, and to a potential reduction based on that. Now, one presumes that the figure of 85% is purely illustrative. Certainly it seems to be just plucked out of thin air, and there's no basis cited for it. It could equally have been 25%, or 75%, or 50%. But more importantly, there's just no more than the most vague reference to how that estimate is going to be arrived at. They say, on the evidence, if the tribunal concludes on the evidence, whether survey evidence or otherwise, well, to say that something's going to be estimated on the evidence, that surely can't pass the process test. It's for the claimants to establish a method to estimate the extent of causation in the aggregate. It's not a terribly demanding standard, but it is a standard that must be passed. There must be a plausible methodology, not a generic reference to future evidence that may or may not be available. If all you need to say is, I'll do a survey for some, and for the rest I will advance some evidence. And if that passes the process test, then the tribunal isn't a gatekeeper, it's a rubber stamper.
Can I ask you about the process test? It's obviously not a test which comes out of legislation. It's been endorsed elsewhere and in these courts. How is the CAT meant to treat it? I mean, to what extent? I mean, it's fairly broad brush. Merrick's, they suggested it wasn't a terribly hard or onerous test to overcome. I can see that if you take the ingredients, that evidence must be plausible and mustn't be entirely hypothetical or speculative, that no one's really going to object to that.
Yes.
Presumably it permits any decision maker, whether it's in the court or the CAT, some degree of flexibility as to how it's applied.
I agree, but there are limits, like any discretion, there are limits to the exercise of that discretion. And if one says, what's the methodology by which you propose to ascertain reliance and causation, the answer is, first of all, an assumption. And then secondly, well, and perhaps for some aspects, a survey, and for the rest, some evidence. Well, that can't possibly pass the test. So, my Lord, if I may then briefly, I only have 10 minutes, I tried to sit down at 12:30 as intended. The second and third grounds of appeal.
Yes.
Can I deal with the third ground next, because it's which is the allegation of umbrella liability. And really, we approach this issue from a slightly different angle than Mr. Harris. We don't submit that this umbrella claim, or like knock-on claim, is apt to be struck out. But we do say that there was no evidence presented to the court of a methodology by which it could be resolved, whether factual or expert. So it is a specific example of our main complaint. Now, the fundamental difficulty for the claimant's allegation is that the defendants don't control the way that the third parties sell their tickets. And you can see that in Mr. Cameron's statement, which you'll find in the supplemental bundle at page 258.
That's bundle 1, is it?
Yes, forgive me. File 1. At paragraph 28, he says, generally speaking, prices are the same irrespective of the retailer. While the signatories of the TSA are required to sell particular fares, the same obligations don't extend to third parties. Third parties are licensed separately under a third-party investor license. Individual TOCs cannot require third parties to sell particular fares, including boundary fares, or dictate to them how fares should be sold.
Can I ask why? Why can't they? It's their network.
That's the contractual setup.
I think, well, I think that's the way the industry is regulated and the way the contracts operate, and there's no challenge to this evidence, as I'm aware.
But I mean, it might be important, it might be important to explore when you're effectively saying it's nothing to do with us, it's not our fault, it's entirely for them, but it's still travel on your networks, tickets made available by you to third parties for retail, you under an agreement pursuant to which you have to honour the travel card. And I'm not quite certain why you assume a degree of control over that ticket. It may be the regulator says you cannot, in which case that might be an answer, but I'm
Well, I think
surprised.
one can see why the regulator might say that, because you're in competition, as Mr. Harris said, you're in competition with Trainline and others, not over price principally, but principally over method of sale. So if you get to dictate your competitor's method of selling arrangements, how they promote boundary fares.
So can you not say to them in law then? Is it your position you cannot say, sorry, there's a lot of banging going on behind me, I hope you can hear.
I can.
Can you not say in law to your third party reseller, you must honour travel cards? Is that prohibited? Well, maybe don't speculate now if you want to think about it, but it seems to me it could be relevant as to what have you got the ability, because it's under the travel card arrangement.
My lord, I will if I may come
Don't
back to
speculate.
it,
Come
because
back
I
to
better that I don't.
I think that's better. Yeah.
We can certainly come back to it. But certainly, as you've seen the evidence, that that's the understanding. So, the way the point is put is quite tentative, really, and one sees it in the reply rather surprisingly. If you see, which is where one first sees the germs of what becomes the umbrella liability allegation, and that's in that supplemental bundle at page 218. And the heart of the, one sees the germs really, it's the second point that they raise in paragraph 38. And what they say in the middle of 38 is that the practical effect of the proposed defendants themselves making boundary affairs sufficiently available and publicising their availability would have been to give third-party retailers every incentive to make them available as well. Well, I say it's tentative because it's just speaking in terms of incentive. It's not actually saying clearly that they would. And it certainly stops short of an assertion that in the counterfactual, all of the third parties would in fact have responded to that incentive by actually offering boundary fares to precisely the same extent as the train operating companies. And there's no explanation here or in Mr. Holt's expert report as to how it would be ascertained whether or to what extent third-party retailers would have responded in that way. Now the judgment, if one goes back to the judgment, in the core bucket, forgive me for dotting around continuously, you'll see that at page 186. It identifies this also as a common issue. You see in paragraph 135 of the judgment, 135.3, it says whether, if boundary fares were available for all the respondents' outlets and or made known more widely, independent third-party sellers would themselves have offered boundary fares and or made them known to customers. Now, the tribunal's right to identify this as an issue, but with respect its articulation of the issue is a little too binary, because the relevant question isn't simply whether the third-party sellers would have made the boundary fares more available, but it must also be to what extent would they have made them more available or publicised them. Now, the tribunal itself draws an analogy with umbrella pricing in its judgment, as Mr. Harris has already shown you, where non-cartellists selling the same goods raise their prices under the umbrella of the cartel. But even in the case of umbrella pricing, it's not always the case that umbrella companies raise their prices all the way up to the cartelised price. Often it's in their interest to raise their prices slightly, but not fully up to the cartelised price. And that's how they gain market share. So too in this case, one can see that third-party sellers might, in the counterfactual, choose to promote boundary fares or make them more available, but they might choose not to promote them to the same extent as the train operating companies. And of course, added to that, how multiple third-party sellers would have hypothetically reacted is not an issue that necessarily falls to be resolved the same way for each third-party seller. It might be that some third-party sellers would have made boundary fares more readily available in response to the TOC's doing so. It may be that others wouldn't. Now, this issue we see it's dealt with, sought to be dealt with in the judgment, paragraph 70 to 72. And it notes, you see that it notes that LSER argued that the claim should be struck out in this respect. And it says that we don't make that argument, but instead say that there's an absence of any proper basis for the extension of the class and the absence of any damages methodology. And we see in paragraph 71 that they recognise that the third-party sellers are probably not agents as a matter of law for all purposes, and they don't explore the agency relationship. They say that the position is broadly analogous to umbrella pricing. And then in 72, they reject the argument that the economic evidence should have addressed the way that the conduct of the train operating companies is likely to have influenced third-party retailers. And you see they say this at the end, on the top of page 159. An applicant for a CPO is not expected as part of the application to put forward its full economic evidence. This point is a matter of the likely causation of loss, which will no doubt be explored further if a CPO is granted. So there is no expert methodology put forward by the tribunal, or recognised by the tribunal, for establishing how these third-party retailers would have responded. And we accept, of course, that it's possible that this could be resolved by some other method that doesn't involve expert evidence. We don't say that a process methodology has to be an expert methodology. It can be a factual methodology. But we do say there must be a methodology of some sort that is identified. And the applicants have just put forward no methodology. They just have an assertion, again, about the existence of alleged incentives. Completely bare assertion, unsupported. That this really is purely theoretical and hypothetical. So, my lord, that's what we say on the third ground of appeal. And on the second ground of appeal, essentially we observed that the tribunal found that on a cost-benefit analysis, the costs weighed slightly against the grant of a CPO. And the judgment, you see that in the judgment of paragraph 165 to 178. Now, we say that through no fault of its own, the tribunal proceeded on an erroneous assumption about the calculation of costs because they were understated to the tune of about 1.3 million by the claimants. And so actually, we say the budget should have been that much higher. And it's likely, of course, that we say that other elements of the costs will prove to be underestimates. And we say again that this is a point that one has to see in conjunction with the points that I've already made about the absence of methodologies. Because if these methodologies had been properly identified, a methodology for uptake by the class and a methodology to judge how the train operating companies would have reacted, then one would have seen a very different balance of costs and benefits, because you would have to have put into the mix the costing for the survey, the costing for all of the factual evidence to make good these non-existent methodologies. And we say that this is another matter that means that this is a collective proceeding order that cries out for reconsideration. So, my lords, my lady, those are my submissions, unless there are any questions.
No, thank you very much, Mr. Jowl.
My lord, may I just give you two references to the evidence because it would help in light of the arguments this morning. My learned friend, Mr. Jowl, took you to Mr. Cameron's evidence about not being able to dictate the terms of sale for third-party sellers, and Mr. Backway, because we have different witnesses, obviously, because of different train operating companies. His exactly the same evidence is at Supplementary Bundle, Volume 1, tab 10, page 313, at paragraph 76, and he states there that there's no individual contractual relationship with third-party reelers, and then critically, and no means of dictating the terms on which third-party sellers may offer LSER fares for sale. And just as Mr. Jowl submitted as regards Mr. Cameron, that evidence from Mr. Backway for LSER was uncontroverted. So that is the basis upon which, factual basis upon which we sought to strike out on that point. And then whilst I'm fortunate, the other reference is in the same statement. It's to be found at page 308. Running over to 309, and it goes to the question of ticket vending machines. So the uncontroverted evidence in the case of my client was that ticket vending machines on platforms are, and I quote, queue busters. They are, and I'm quoting here, intended to be simple, quick and intuitive, and they're intended to reduce the number of passengers purchasing fares at the station from ticket offices. The reason I raise that plainly, my lord, is because it goes to my learned friend's point about how even if you only have one more screen and then people stand there scratching their heads and people are backing up behind them, and then it goes to another screen and then they stand there scratching their heads even more, and then they get frustrated, and then some of them don't speak English. Frankly, even if you do speak English, once you go through multiple screens, it can become befuddling. And then if there's a third one that says, is your travel card going to be valid on the return date? And before you know it, they're not queue-busting devices. But my client, and this was not challenged, made a policy choice that TVMs were to be queue-busters. And introducing this further level of complexity is not consistent with that. And then just finally, to completeness, if you were to review the next paragraph, my client also took a slightly different view as regards the availability on TVMs during part of the claim period for a completely separate reason that hasn't been mentioned, and it was to do with fraud prevention. A TVM cannot tell, by definition, it's a machine standing on the platform, whether you actually have in your possession a valid travel card. So it would have to take on trust that you do. And you might say, well, okay, but you know, if some TOC did that, why couldn't yours? Well, the uncontroverted evidence from my client through Mr. Backway is that it has, and I quote, a large number of ungated stations, and there's therefore a heightened risk of passengers seeking to take advantage of ungated entry or exit points by buying a ticket that is not valid for their entire journey. In other words, somebody could go to a TVM at an ungated station or buy ostensibly a boundary fare, but then go through at an ungated station and do some of the journey without paying anything at all. Because when that boundary fare is sold by the TVM has no idea whether they've got a travel card, because it's just a machine. And so,
unless there's a ticket inspector on the train,
yes,
that's
and
a
that's
risk that your clients run with any
true.
business passenger about any fare, and somebody who wants to cheat the system can get on the train without paying full stop.
That is true, but this is an identified category for a network that has a, quote, a large number of ungated stations, and they say we're entitled to protect ourselves against revenue fraud. And this is one of our reasons. Anyway, my point is not, I don't want to overlabel the point, but I just wanted you to know that there's a factual evidence there, and there's a slight distinction in the facts between my client and those of my learned friend. I didn't want, unless I can assist further. Thank you very much.
Yes, Mr. My lady, my lords, in opening, I have 23 minutes now, and then roughly 2 hours this afternoon. I do, of course, have some time tomorrow morning. What I plan to do today, tempting though it is to delve straight into what we've just heard from my learned friend Mr Jowl on a sort of extempore basis. But what I had planned to do today is to respond to my learned friend Mr Harris and what he said yesterday, and then if my timing works out, come to the points made by Mr Jowl tomorrow. Although to some extent, of course, they overlap, and I may pre-advertise some of what I have to say. But I'd like to touch briefly on the issues and the abuse with which we're concerned in this case. As Mr Jowl did, Mr Jowl has taken the court to the common issues which are identified in the CAT judgment at paragraph 135, which is at page 186 of the core bundle. I'd just like to start there, just to ground ourselves in what it is that the CAT says is going to be dealt with at trial. One, whether the respondents held a dominant position at the relevant time. There's nothing that concerns us about that. If it held a dominant position, whether it abused it, one, to the extent that boundary fares were not available from respondents' outlets, and to the extent that boundary fares were not available for all discounted fares, in particular advance fares, and to the extent that where boundary fares were available, there was a widespread failure to mention or explain this to customers. In response to some of what Mr Jowl said this morning, when Mr Jowl says they are available, so for instance they are available from ticket counters, that is very much a question of what you mean by the word available. And the evidence, as I shall shortly come to, that was before the CAT, in particular from a survey, as it happens, done by a company called Decidedly, was that availability was essentially a formality, but not in practice availability. There was further defined as a common issue whether, if boundary fares were available for all of the respondents' outlets and or made known more widely, independent third-party sellers would have offered them. We've just heard from Mr Jowl about that, and I'll come back to it. Whether the customer who was aware and had the opportunity to purchase it would have done so. And 5, a question of mitigation, whether a customer failed reasonably to mitigate their loss by not purchasing a point-to-point fare from the last station covered by their travel card to their destination. And that is now a point of mitigation only, because as my Lord the Chancellor has pointed out, the point-to-point fare is excluded from the class, in the sense that people who've bought it are not within the class. So we then heard from
my learned friend, Mr Jowl, that we have somehow changed the infringement or abuse from one of strict liability to some lesser form. As your lordships, my lady, well know, there is a fundamental difference between the parties as to the extent to which the single word ensure meant that somehow our case was different when first pleaded. It's certainly not how we saw the abuse. That was a matter that was raised with the cat at the very first CMC before the hearing. And at the very first CMC, the President said, I'm not going to accept the idea that the use of the word ensure somehow means that this is a case on strict liability. And it has been treated at all material times as a matter of sufficiently available or similar. I have had inserted into the bundles before the court our re-amended claim form. What has happened, because this is of course certification case, it's at a very early stage. There's been no disclosure apart from one item. What has happened is that we have re-amended our claim after the judgment in order to reflect things like the removal of point-to-point and so forth. And we've taken the opportunity to adjust things like the definition of abuse, maybe for convenience, but I've put it in there so that the court can see it. That is not yet the claim, because what happened is that my Lord Justice Green's stay intervened when permission was granted to appeal, and so no re-amended claim form has yet been served, quite rightly. It is at Supplemental Bundle 2, tab 22, page 625 and following.
Sorry, Mr. Mayor, did you say 225?
625.
625.
65.
There you are. For those who do have tabs, it's behind tab 22. There are two, obviously, one for each case. One against South East, one against South West. I'm just going to look at the one, the first one, which is the one against South Eastern. The abuse is first described at paragraph 3, which is on page 626. And the relevant parts of 4 lines down: by failing to make boundary fares sufficiently available for sale, and or failing to use their best endeavours to ensure that there was a general awareness among their customers of the existence of boundary fares, so as to enable customers to buy an appropriate fare in order to avoid being charged twice for part of a journey. Defendants have abused their position of dominance on the relevant markets in breach of the prohibition in section 18. There are similar formulations at paragraph 42 on page 636 under the heading abuse, side heading abuse, by the first hole punch. I won't read it out again. And 107 at page 654. And at 108 we say the infringement arises out of the systemic failure of the defendant to make boundary fares sufficiently available for sale across a variety of sales channels, and or to use best endeavours to ensure that there is a general awareness amongst customers of boundary fares, and so forth. And at 109, it is of no bearing that there will have been a number of different customer journeys. Some people will have bought from TVMs and some from station ticket counters. As the tribunal recognised, this is the re-amended bit, the claims are advanced on the basis of a systemic failure by the defendants to make boundary fares sufficiently available. All of the class members face the same selection of sales channels, all of which have limitations in terms of the availability of boundary fares, whether by design, as in the case of online, or due to lack of staff awareness or available advice to customers. And so forth, and the court can read to the end. This is a case where the estimated number of class members for the UK resident opt-out is about 3 million. I'll just give the reference of paragraph 5 of the judgment. And the estimated central estimates for individual payments per UK-based claimant are between £33 for the South West network and £55 for the South East network, and that's the judgment of paragraph 165. The prima facie case, based on the single bit of substantive disclosure we have so far, is, in my respectful submission, very strong. We have the percentage sales of boundary fares, and again that the reference is judgment paragraph 20, and out of the millions, even hundreds of millions of in-scope journeys taken, only a few tens or hundreds of thousands of boundary fares were actually sold. Less than 1% in the southeast, and between 1 and 1.5% in the southwest. We do say, and we based this on our legal submissions in relation to cases such as Deutsche Post and DSD, which are in the judgment, we do say that customers may be presumed not willingly to pay twice for the same product. In this case, the same stretch of the journey. And so we say that the combination of what we have grounded in the bit of fact that we have been able to see and the law, that there is a very compelling prima facie case that essentially all the rest, the vast majority of travellers overall, were affected by the alleged abuse. And at paragraph 21, the CAT has found, as a fact against which there is no appeal, that boundary fares were purchased for a very small proportion of in-scope journeys. That is at page 137 of the core bundle. If we can go there, please. We will see at paragraph 137, and I know the court has familiarised itself with this well, the tables setting out the figures for journeys and boundary fares.
Sorry, which?
137, paragraph 20 of the judgment.
Yeah, sorry, it's paragraph 20, yes.
So we've got the figures that I've just referred to, and the finding in the first sentence of paragraph 21 that I've just read out.
Yeah. So just over, well, 1.5% as it were for South West and less than 1% for South East.
My lord, yes. And we then see what I've referred to as it depends on the meaning of availability. Over the page at 138, the boundary fares of all the respondents are available at their station ticket counters. Well, that is common ground in principle. The availability of boundary fares from the respondents' other outlets varies. Just a comment, of course, on the availability at the ticket counters, and I'll come back to them because there is a description of it in the judgment. But as I think it's clear that the case, as we put it, as we suspect it to be, and as decidedly found it to be, was that you can go up to the ticket window, where in theory the boundary fare is an available fare, And we heard below that there is a database of about 1,000 different fares, and the boundary fare sits somewhere in that database of 1,000 fares. You are not asked if you say, I'd like a ticket to Reading, please. Have you got a travel card? In most cases. In some cases, even if you bring up the fact that you have a travel card, you are not then directed to the reduced fare. That's the evidence of the survey, such as it is. So, available at the station ticket counter, as my learned friend Mr Jowl put it, does not mean, as the casual listener might have concluded, that there is no abuse here. On the contrary, we say it's a particularly egregious example of the abuse, that they are made in quotation marks available, unquote, but as it were kept under the counter, figuratively speaking. So you have to know it's there. Again, figuratively, in that drawer of 1,000 boundary fares, you have to know that's one of them. Not sorry, boundary fares, of 1,000 fare types. You have to know it's one of them. So that's the ticket window, most of the time not mentioned. Other outlets, first, so that's Southwest, sells boundary fares from about 84% of its own TVMs. And that's why Mr Jowl was no doubt keen to point out his own client's situation. On a limited number of others, its own call centre. The position as regards online sales is not altogether clear. The decidedly survey indicates no boundary fares online. Stagecoach, that was the previous operator, sold boundary fares. Then it had some stickers to say you can call a call centre. Southeast doesn't sell boundary fares at its own TVMs or online. We heard Mr Harris make the point from his own evidence. They've sought to justify that by the fraud explanation. That was the same explanation below. That wasn't self-evidently not considered persuasive below. So what happens? You have a passenger who comes to the station. Everybody faces the same outlets. You might have gone online beforehand. You wouldn't have found a boundary fare there. You might go to the telephone lines. You wouldn't, in third parties' cases, have found a boundary fare there. You wouldn't, as far as one can tell, in most cases with the TOCs, have found a boundary fare there. You won't find a boundary fare on any southeastern ticket machine. You might find it on the first MTR machine, if it's one of the 84%, but it won't be straightforward. There certainly won't be a pop-up window that says, oh, you want to go to Reading, have you got a travel card? You can try and get it at the window. What we see the decidedly survey said is at paragraph 26, page 140. Point 1, at the ticket counters, if you don't initially mention you have a travel card, between 89 and 83% of the time, you weren't prompted. And 2, at the in-station TVMs, although boundary fares were available, purchase option was complicated, not able to locate without assistance, not available in LSER, not available online, not generally available in third-party telephone-based sellers, low staff awareness, and in the case of Train Genius, not able to sell them at all. There is much mystery sought to be generated by the other side around what we say the appropriate counterfactual But in my respectful submission, when you look at this, this is an almost laughably straightforward situation. The counterfactual is not at all difficult to describe, and we see some of it described at paragraph 67 and 68 of the judgment at page 157. The top bit of 157 is the end of 67. And the counterfactual boundary fares would be available for purchase through all sales channels, offered both to inquiring customers and generally easy to locate, clearly labelled. There would be consumer-facing information regarding their existence or use. And it was accepted below that in relation to boundary fares not being at all available, what the respondents should have done is clear. And it's also pointed out at 68, 4 lines down, to establish an abuse, it doesn't require the identification of a counterfactual in specific detail. And there's more there, and at the end of 68. Examples in the claim form refer to the possibility of better staff training, amended sales procedures, and in general terms, in the same way as off-peak fares. Well, quite. You tell your staff to ask for travel cards in the same way that they ask for rail cards, and then actually to offer the cheaper price. You offer it on the TVMs, the machines. You offer it online. In both cases, as unprompted at the court immediately and put to my learned friends, the first screen will say travel card. Yes. And then you go on from there. You put up posters, not just a poster, as my learned friend suggests, although if it's as easy as that.
Well, it's like if one starts thinking about it, in a sense, the argument that well, passengers, you know, the sort of consumer apathy point that people can't be bothered is really, you would say people can't be bothered because they're not actually promoting this in the right way. And if they were promoting it in the right way, which made it straightforward and simple to actually buy, then you say, well, everybody would do it.
Absolutely, my lord. But to some extent, many of these points mischaracterise the counterfactual. Because in the counterfactual, we posit there would be a general awareness of boundary fares. So of course people would buy them in the same way that you buy an off-peak fare or use your rail card, which you bring. There is no mystery. This is a highly homogeneous class. London rail travellers, all faced with exactly the same range of purchasing options. Quite a limited number of situations. And something has very obviously gone wrong, where they've ended up double charging on at least 98.5% of journeys. And the people in those 98.5 to 99.3% of situations now make up our class. And if only you had an advertising campaign, I don't know, are you going to Boundary Fair? Remember you can use your travel card for the first part of your journey. We do say it is a situation where it may reasonably be presumed that no one would willingly pay twice for the service, and then, as it were, you start the evidential debate from that point and seek to discount those, I say, with respect, somewhat exceptional cases where you say, oh, well, but there would be a small number of people who forget their travel card once in a while. And you say, all right, well, that's to be proved at trial. And they can bring evidence, and they can say, well, our evidence indicates that 1% of people forget their travel card. And then you make an appropriate reduction. We don't say that that is something that is either improper in an aggregate assessment or something the tribunal wasn't entitled to find. And I will say, and this is, I'm aware of the time, so I'm going to finish this little introduction and say our simple riposte to Mr. Harris's claim that if this is precisely the sort of case that ought not to be certified, our simple riposte, and it's probably unsurprising is if this case is not suitable for certification, then no consumer-based class action will be certifiable by the UK courts. And I'll return after lunch, if I may, with my specific responses to Mr. Harris's points yesterday.
2 o'clock then, please.
Authorised. Ending the large straight knot